Detailed case summary. British Crane Hire Corporation Limited v. Ipswich Plant Hire Limited, 1975, is a landmark case in English contract law that addresses the enforceability of standard terms in a contract, particularly when both parties are in the same line of business and one party has superior bargaining power. The court examined whether standard terms, not expressly agreed upon but previously used between the parties, could be implied into the contract. Background facts. Claim and plaintiff. British Crane Hire Corporation Limited. Defendant, Ipswich Plant Hire Limited. Background facts. Ipswich Plant Hire Limited urgently needed a crane and hired one from British Crane Hire Corporation Limited. The parties had engaged in similar transactions previously. In this case, the crane got stuck in marshland, necessitating expensive recovery operations. British Crane Hire sought to recover these costs based on a clause in their standard terms, which Ipswich Plant Hire had not expressly agreed to for this specific hire but had accepted in previous dealings. Argument in the court case. Plaintiff's argument. British Crane Hire Corporation Limited argued that the standard terms, which included a clause making Ipswich Plant Hire responsible for recovery costs, were implied in the contract based on the previous course of dealings and the industry norm. They asserted that Ipswich Plant Hire was aware of these terms and had implicitly accepted them by continuing to do business. Defendant's argument. Ipswich Plant Hire Limited contended that they had not expressly agreed to the standard terms for this particular transaction and thus should not be bound by them. They argued that imposing such terms would be unfair and that there was no clear evidence that they had accepted the terms for this specific contract. Final outcome and legal justification. Final outcome. The court ruled in favour of British Crane Hire Corporation Limited, holding that the standard terms were indeed part of the contract. The judgment established that where parties have a history of similar transactions and are aware of each other's standard terms, those terms can be implied into the contract even if not expressly agreed upon for that particular transaction. Legal justification. The court's decision was based on the principle of implied terms through a consistent course of dealings and the nature of the industry. The judgment highlighted that in commercial contracts, particularly where parties are of equal bargaining power and familiar with each other's standard terms, those terms can be considered binding. The court noted that Ipswich Plant Hire Limited had knowledge of and had previously accepted these terms, thus they could be implied into the contract despite the absence of an explicit agreement for this specific hire. Key concept. The British Crane Hire Corporation Limited v. Ipswich Plant Hire Limited, 1975, case illustrates the principle that standard terms can be implied into a contract based on the previous course of dealings and industry norms. It emphasizes the importance of understanding and accepting standard terms in commercial transactions, especially when there is a history of similar dealings between the Key learnings. In commercial transactions, especially between businesses with a history of dealings, standard terms can be implied into the contract even without explicit agreement. Familiarity with the other parties' standard terms and industry practices can bind parties to those terms. Legal practitioners should ensure that clients are aware of and explicitly accept standard terms to avoid disputes. Understanding the precedent set by this case helps in recognizing the significance of implied terms and the role of industry norms in contract law.